Are we live, Ms. Dean?
Yes.
Okay. All right, let's go on the record on cause number DC 2016884, Tracker Services LLC versus Tower Rock Oil and Gas LLC and Brian Portner. Counsel, make your appearances.
Yes, Your Honor, this is Javen Porter here on behalf of Brian Portner and Tower Rock Oil and Gas.
And you have Michael Tristan of Thompson and Knight LLP, also on behalf of Tower Rock Oil and Gas LLC and Brian Portner.
Matt Daigle on behalf of Tracker Services LLC.
Okay, so one of the things I frequently say as a judge, as I've been doing this for about 15 years, is that you see something new every week. Well, this is definitely my new thing. I've never seen anyone in a situation like this try to do an interpleader, but we'll see how it goes and love to hear the argument. So we're here on a summary judgment. Let's get started.
Yes, Your Honor, I'm going to share my screen if that's okay. I have a PowerPoint I'd like to go through.
Sure.
I think you all have the host is disabled the screen sharing.
No, I've enabled it.
Okay, there we go. Yes, Your Honor. So just some background on this case. You know, Tracker and Tower Rock, we're parties to a settlement agreement. And really the reason we're here is Tracker believes that it is no longer liable to pay Tower Rock under that settlement agreement. And to prove that, as you said earlier, that they've decided to file, which is kind of curious, 2 separate lawsuits against Tower Rock. This is Dallas County interpleader action, and then also a Reeves County action. And that Reeves County action is now a fraudulent inducement action and an unjust enrichment claim. And we brought a breach of contract counterclaim in that case. But the Reeves County case began as a deck action, basically over title to determine, whether we had title to the property and payment under the claim. We filed an MSJ there. Now it's, they've amended to make it a fraudulent inducement and unjust enrichment action. But just to make a point, we do feel like today is important, and, we need a ruling because on Thursday, there's a plea and abatement to be heard in Reeves County. And in that plea and abatement, Tracker is attempting to force us to litigate our breach of contract claim here. And we'll talk a little bit about, how they're trying to position themselves to even be discharged from this case. So it really is important today, Your Honor, that we feel like it's important that we be heard on this. And we think there is clear summary judgment grounds to move on this case. And really, it starts from this, the first thing that Tracker cannot prove is that double liability exists. A plaintiff cannot create double liability, and it's undisputed today that Mr. Portner is not making a rival claim at the time the petition was filed. And, interpleader, as we all know, is a party is entitled to interpleader relief when it establishes 3 elements. And we're really going to concentrate on this first element today, but it is either subject to or has reasonable grounds to anticipate rival claims to the same funds. If you look at this next slide, I think Rule 43 is really clear. It says persons, plural, having claims, plural, against the plaintiff may be joined as defendants and required to interplead when their claims are such that the plaintiff is or may be exposed to double or multiple liability. And that typical interpleader scenarios, as you see this little chart below, is you have a plaintiff, they interplead the funds, they unconditionally tender the funds into the court, and then the court decides which of the 2 claims it goes to, which of the 2 defendants then it goes to. And that is a typical interpleader. And, you see these examples all the time of life insurance policy with one party saying they get the life insurance policy or another party saying it, and the insurance company doesn't know who to pay, so they interplead the funds. That's 2 or multiple liability, double or multiple liability. And we just don't have that in this case, Your Honor. And if you look at what Tracker is trying to argue, I think it really is a juxtaposition of what a typical interpleader case is. You see Tracker is saying that they can unconditionally tender the funds into the court, interplead the funds, and then the court decides whether Tracker gets the funds or Tower Rock gets the funds. And no Texas court has ever found double liability in this scenario. And if valid, every single breach of contract case is going to be litigated through interpleader from now on. And really, it's going to just, throw into, it's going to really complicate how a breach of contract case is litigated and how you go about finding who owes who funds under any type of agreement. And it's just not how it's supposed to be done, because this is a typical breach of contract case. As you can see, really, you can just turn this around. Tracker sues Tower Rock, and then the court decides who gets the funds. And that's how this should be handled, Your Honor. And then the second argument we're going to make is double liability does not exist. It is undisputed Mr. Portner was not making a rival claim at the time the petition was filed. And that is the pivotal time under Texas law when the court should decide whether interpleader jurisdiction is proper. Tracker has done nothing to rebut the Portner affidavit. The Portner affidavit that was attached to our summary judgment motion, in that Mr. Portner says, I am not making a rival claim to the interpleaded funds in this lawsuit. Tracker is not subject to multiple liabilities on my behalf. And not only have they not done anything to rebut that or done anything to put any evidence up that says anything differently, they agree in their response. Says, without agreeing to the persuasiveness or veracity of a claim, petitioner agrees that Portner is competent to testify as of the date of his affidavit. He was not a rival claimant to Tower Rock. And that is the only evidence before this court today on motion for summary judgment about a rival claim. And it has not even been, it's undisputed, Your Honor, that Mr. Portner was not making a rival claim.
Is Tracker making a claim to these funds?
Yes, Your Honor. Tracker, I guess, is trying to make a claim to these funds. But again, that is not double liability. If Tracker makes a claim, that's just a typical breach of contract lawsuit, because Tracker is the interpleading party. So that does not create double liability under, Rule 43 or under any of the precedent in Texas. No court in Texas has ever recognized interpleader, no double or multiple liability when the plaintiff is the only other rival claim. No court has ever done that, Your Honor. And then the Texas Supreme Court precedent, just talking about when jurisdiction is important, when it's determined jurisdiction. Rodriguez case, the most recent case really from the Texas Supreme Court on interpleader, it said interpleader jurisdiction is determined at the time the interpleader complaint is filed. And then if you kind of combine that with McFarland, another Texas Supreme Court case, you really get how to look at when, a rival claim matters and how to really determine what is a rival claim. And McFarland says the mere possibility that facts giving rise to an adverse claim could exist does not constitute reasonable grounds. So if you take those things together, Tracker cannot sit here today and argue that, one day Portner might make a claim, so that's rival claims. That's just completely against Texas precedent. They have to show today that at the time the interpleader was filed, that there was rival claims. And they cannot do that because they can't do it because the Portner affidavit has not been disputed. It is the only evidence put in today for the motion for summary judgment talking about a rival claim, and it says I'm not making a rival claim. And I think it's important to just think about what they're trying to say, because Portner, we represent Portner. He is our client, and he brought this motion on the grounds that he will not make a rival claim. And then no document exists today, Your Honor, that evidence is a rival claim. The only evidence today in front of you is the fact that Portner is not making a rival claim. And just this last point is more just in general about how unique and really just there's no precedent for what Tracker is trying to ask the court to do. Is a plaintiff cannot be discharged from an interpleader and still present defenses to liability to pay the funds. And that's what Tracker is attempting to do today, Your Honor. And you look at it, it is admitted, Tracker's admitted it is interested party. If you look at they say in their petition for interplay, they say Tracker Services is excused from making the second payment under the legal theories identified above, and this sum should remain within Tracker's possession. They are going to put up legal theories saying why they should keep the funds. They are interested. But then also Tracker is trying to be discharged from this case at the same time as forcing Tower Rock to litigate its breach of contract claim against it in this case, Your Honor. So it's just, that has never been recognized in Texas. And then no Texas court has ever recognized interpleader in this scenario. And Tracker tries to cite cases and say that they are interested party cases, but they're not. Those cases deal with double liability. First of all, they actually have two defendants against a plaintiff and interpleader saying they have the funds. We just don't have that here. So that's one way they're completely different. And then they also all those cases concern attorney's fees. And Tracker's attorney's fees are not even in dispute. Tracker will never get attorney's fees in this case because they've already said they're interested. So basically, Tracker is trying to get this court to recognize a completely unique interpleader where they say we don't get attorney's fees, but we want you to discharge us from the case and then force Tower Rock to bring its claims against us in this case once we've been discharged. And that's never happened in Texas, Your Honor. No court's ever recognized that. And, what does Tracker want? And I think if you read, like I said, they want this, their petition, they want this court to enter a judgment which discharges Tracker from the case and joins Tower Rock and Portner from taking action against it and determines how much the interpleaded funds should be distributed to the rival claimants. And they consider themselves a rival claimant, so determine how much should be given to them, even though they're discharged from the case and you can't present any liability against them. Well, just not even taking into account what we've already said, that's never happened in Texas, just to make a point, if Tracker is discharged from this case, Your Honor, the first thing that Tower Rock and Portner is going to do is they're going to enter a judgment and an agreed order that says that Tower Rock should get the funds. So then what's going to happen? Well, Tracker is going to try to attempt to put up why that should not happen. And that's just not a proper interpleader. And that's never been done. It just goes to show you the procedural issues we're going to have in this case if the interpleader is actually recognized. But the good thing is there's clear summary judgment grounds here, Your Honor. And the clear summary judgment grounds is there's no rival claimants, there's no multiple liability. And that's because Tracker can't be a rival claimant under Texas law. And Portner, there is no disputed fact that it's undisputed that Portner is not making a rival claim himself. The only claim to this funds is made by Tower Rock. So just on the very first ground of an interpleader, Tracker fails. And that's why, the summary judgment should be granted. Thank you, Your Honor.
Response?
Yes, Judge. The defendants in this case have gone out of their way to try to create confusion and conflate various issues on very clear Texas law. The way to think of these two lawsuits is very simple. There is a settlement agreement. Tracker Services made the first payment under the settlement agreement in the sum of $200,000 to the defendants. We subsequently discovered the fraud of the defendants. And so the second payment that was due under this settlement agreement in the sum of $200,000, we decided to file an interpleader, and then we deposited that sum into the registry of the court. The cause of action that we have filed in Reeves County, it's located in Reeves County because it has to do with some real property in Reeves County and it has to be there. That cause of action in that lawsuit is to recover the first payment. Obviously, we are presenting a theory that we are entitled to a recovery of that payment due to the alleged fraud. Fraud or some sort of improper means of procuring a benefit is a required element of unjust enrichment, which is what we are pleading there. We don't have a claim for breach of contract. It doesn't have anything to do with this action here. This action is a typical interpleader. We have a payment of $200,000. Tracker Services believes that it should be made.
How is it a typical interpleader? I'm a little unclear about y'all's position in this case. Are y'all saying that this money should go to one of the two defendants and it's not, you don't care who it is? Or are you saying that, which I think is what you're saying, is that you want to deposit this money in the registry of the court, and then your client also wants to make a claim to this payment?
Yes, Judge, just the latter. Tracker Services is an interested party with regard to this sum. We deposited into the registry of the court in order to act in an abundance of caution. We believed at the time that the defendants would be more interested in having the money in the registry of the court than having it essentially in my client's bank account. But for whatever reason, they've decided that they would rather have this money go back to my client, which is the result of dismissal of this action today. Really, Our biggest issue with the defendant's position is they are trying to impose additional restrictions on the availability of interpleader than that which exists in Texas law. The only restrictions are found in Texas Rule of Procedure 43 and the 3 elements, and they are that a party is subject to or has reasonable grounds to anticipate rival claims to the same funds, that it has not unreasonably delayed filing the interpleader, and it has unconditionally tendered the funds into the registry of the court. Defendant's motion did not address element 2 or 3. Their reply filed 3 days ago for the first time seemed to make an argument that Tracker Services did not unconditionally tender these funds, and that's just not supported by Texas law. Depositing actual cash into the registry is an unconditional tender as a matter of law. So we're really only talking about element number 1, whether a party is subject to or has reasonable grounds to anticipate rival claims to the same funds. By the defendant's own admission, Tower Rock is a claimant. By our pleadings, Tracker Services is a claimant. And it seems that the defendant's problem is they believe that we are trying to be discharged from this lawsuit and it would result in no rival claimants. What we are seeking discharge of is our obligation to make this payment to Tower Rock. As an interested party, we're not seeking to be dismissed from this lawsuit.
If you look at O'Connor's, I don't know if you have O'Connor's there. There's a case that's cited. I have the 2019 version. But it's in the section on interpleader, section 3.3, sub 3. It says specifically, the stakeholder is an interested stakeholder because it asserts a claim to the interpleaded funds, and thus interpleader is improper. And it cites to a case, Fort Worth Transportation Authority, 547 Southwest 3rd at 852, and also Financial Services Casualty Corporation versus Transamerican Life Insurance, 523 Southwest 3rd, 129. And then it has a whole discussion about below that about what is a disinterested stakeholder. And it seems to say that it's, clear-cut Texas law that if you're an interested stakeholder, interpleader is improper. What cases do you have that says an interested stakeholder can assert a interpleader action?
Sure. It starts in our response on page 8, the top of page 8. The litany of cases begins with, I believe it's 1981. Yeah, Brown v. Reserve Oil Inc., 626 Southwest 2nd, 810. This case specifically holds when the interpleading party is responsible for the conflicting claims to the funds or property, it can still qualify for an interpleader. The court, we cited to several cases where.
So what are the facts of that case?
Can
you share screen it for me?
I don't have it pulled up. I'm sorry.
Yeah.
And Judge, I think I can shed a little bit of light on the confusion here. The cases that the defendants are talking about all say that an interested party cannot qualify for attorney's fees. None of them say that an interested party cannot qualify for an interpleader.
Let me see more about the facts of this case.
You want me to scroll down, or what do you want me to do?
Yeah. Is there a discussion about interpleader and interested parties?
Your Honor, if I can make one point about this case too, this case also clearly has double and multiple liability because there's multiple defendants making claims against the plaintiff. And we do not have that in this case. And that is a clear point of why this interpleader fails, because Tracker cannot make rival claims and make multiple liability themselves. In this case,
Judge, that is not what the law says. The law does not say that we cannot qualify as a rival claimant. Furthermore, the law also says that present claimants are not needed, that we need to anticipate rival claims. And it is without question that the other defendant could have some real issues here in conflict with Tower Rock. His affidavit says that he will never make a claim to these funds. And frankly, that's just pure speculation. Any affidavit or any testimony that purports to see into the future for an unlimited amount of time is not evidence. It's not testimony. It's not competent summary judgment evidence for sure. It really doesn't mean anything. And even if it was.
So what this case says is, I think is the key point. It says when the interpleading party is responsible for the conflicting claims to the funds or property, that party is not entitled to attorney's fees incurred in interpleading the claimants. And it cites the Texas State Bank and Trust versus Pateo.
Your Honor, another point about this case too is this case and other cases, the parties are interested in the actual underlying litigation. They're not also interested in being discharged from this case and also making a claim to the funds. That's a different part. In this case, the party it created the interpleader problem. That's why that's why I was interested. And also it wasn't interested in the funds. It said, here's the funds. We owe this much money. Well, that's not what Tracker is doing. Tracker is saying we don't owe that money. They're basically trying to make a very clear breach of contract claim into an interpleader, and also doing it while saying they are the rival claim. It is completely against what Tech. And then I would love for Mr. Daigle just to give me one single case in Texas history or United States history in any court that says a plaintiff can create a rival claim. One
Mr.
Texas
Porter,
case.
Sorry.
Go ahead.
I was just going to say, I cited those cases in our response. What the defendants have failed to do is present any rule, case, law, or authority that says that a petitioner and interpleader cannot qualify as a rival claimant to the funds that it deposits into the registry of the court. That's just not a prohibition that exists. Interpleader is a very broad area of the law, and the only restrictions appear in those three elements in Rule 43. There is the other requirement that if you are interested, you can't get your attorney's fees out of it, but none of that requires the dismissal of an interpleader if you're an interested party making claim to the funds. The defendants are simply trying to further restrict interpleader, and it's just not proper.
Well, I think the case law is really unclear, and it concerns me. O'Connor's is rarely wrong, and it specifically says that disinterested parties are not entitled to interplead. I don't know that the case that you cited there is right on point, but I'm going to take this under advisement. If you guys could provide me copies of all the cases, that would be great, either electronically or in a binder. I guess you have some other hearing in Reeves County this week or something. Is that right?
On Friday.
Your Honor, I think it's actually on Thursday.
Oh.
And yeah, so it's the 28th. And one point I'll just make one quick point is Texas Rule 43. It's pretty clear. Persons making claims against the plaintiff. That means multiple people making claims against the plaintiff. It's as clear as it can be on that point. There has to be multiple and double liability. And you cannot create double liability against yourself by making a claim against someone else. It's as clear as it gets.
Not what the authority says. It says, or has reason to anticipate. there is clearly at least 2 claims to the funds in the registry by the petitioner and by Tower Rock, and the petitioner has reasonable basis to believe that Portner will also become adverse to.
What evidence do you have of that?
Well, we have asked in discovery for any transactions on the back end of this underlying mineral transaction. And the way it was structured is that Tower Rock paid $400,000 to the seller, but the seller conveyed these minerals to Brian Portner. We have seen nothing that balances out that transaction, as it were. So we don't know exactly internally how it went between Tower Rock and Brian Portner. What went on there, what payments were exchanged, what deeds were exchanged. We have no idea. And just because the fact that we believe that the title in these minerals are clear, which is what we're fighting about in Reeves County, there necessarily has to be some sort of other element of consideration in between Tower Rock and Brian Portner. They won't tell us what happened. They won't tell us what they did. And that in of itself is a reasonable basis to believe that there could be a real problem between the two of them. We just haven't found it yet.
I mean, I think you have to have some evidence, I would think.
The evidence is the deed going to Brian Portner and the payment going to the seller of the minerals.
Your Honor, I'm going to object to that. That's not before the court today. He can't just sit here and speculate on.
That's not an objection, and it's not speculation. Are you disputing that the payment came from Tower Rock and the minerals came to, and the mineral deed was to Brian Portner? Are you disputing that?
Your Honor, all I'm saying is there's evidence before the court. We represent Mr. Portner and Mr. Tower Rock. They're perfectly aligned today. And they're perfectly aligned in the fact that Mr. Portner says that Tower Rock can receive the funds. There is no rival claim. The only claim being made to this money is by Tower Rock, and Tracker cannot create a claim itself. That's as clear as it gets under Rule 43. And all of this other stuff is just, I think it's just trying to muddy the waters because it's so clear, Your Honor. And the fact that he's trying to go through this whole charade just shows that they have no proof whatsoever.
This is not a charade, Mr. Porter. I don't appreciate that very much.
Hey, don't yell at each other. Direct it to me. All right, I'm going to take this under advisement. I'll get you a decision as soon as I can. It probably will not be by this Thursday, unfortunately. I would urge the court in Reeves County to not abate. I guess they want to abate their own case. Is that the question?
No, Judge, we are seeking only the abatement of Tower Rock's counterclaims for breach of contract because that deals with the payment that still has not been made, which is properly seated in the interpleader because that's the second payment. So the breach of contract claim for the second payment needs to be where the second payment is.
So you want to abate that portion of the case in Reeves County?
Correct, and have it transferred to this court.
I would suggest very strongly and urge the judge in Reeves County to just give me some time to make a decision. We just, this is a unique area of law. I've been doing this for 15 years. I've never seen this exact argument made where a interested stakeholder can claim the funds because I really think that's the only real issue here is it appropriate to have an interested party? Is an interpleader even possible in a situation where you have an interested claimant, or is it just you can have the interpleader but no attorney's fees? And that's where I'm not really sure. And so I'd like to read all the cases and have some time to decide that. So we'll get you a decision as soon as possible. You guys have a good day, okay?
Thanks, Judge.
Thank you, guys. Mr. Wood, Mr. Spector, Mr. Mosley, are you guys here for the 10 o'clock?
Yes, Your Honor.
All right. I'm going to take a quick 5-minute break, and I will be right back. I'll be back before 10.
Actually, Your Honor, I'm so sorry. This is Juan Rodriguez. I was here for the 9 o'clock docket.
Oh, what are you here for what?
It was just for the DWAP calendar. We haven't been able to serve the defendants, but I'm in the process of
give me 1 second. Let me share a screen then so you can tell me what case you're talking about. Which case?
That will be, let's see, Tovar.
Okay. All righty. And tell me what's going on in this case.
Yes, Your Honor. we filed a lawsuit. We've been negotiating with the defendant, and she's asking for final authority to be dealt on Friday, this Friday coming up.
Okay.
And my client unexpectedly was diagnosed with cancer. So
Sorry to hear that.
yes, I'm sorry myself as well. So we were unable to proceed with the case for about 6 weeks. And now we're just waiting for the full and final offer, which is due on the 29th. And I anticipate, because of my client's health issues, that this case is going to settle at that time. So I'm another 30 days to get this resolved.
So Rhonda, let's give him another 30 days. I'm not sure if you're on the call right now. Did you get that, Rhonda? Give me 1 second.
Thank you, Your Honor.
Okay, I'll just let her know later that to go ahead and extend that. I don't think she's on the call at the moment. Wait a minute. Yeah, she got it. Okay. All right. We'll go ahead and give you 30 days. You be safe, and I hope your client's okay.
Thank you, Your Honor. I appreciate that. Have a good day.
All
right. Bye-bye.
We're going to take a quick break, and we'll be back in less than 5. it's not quite 10 o'clock yet, but we'll see if everybody's here on any of these cases. Dallas Oil Services, if you can see the screen, you can see on the bottom there's a scheduling conference. Mr. Wood, can you see the screen okay?
I can. Thank you.
Dallas Oil Service Inc. versus Mulholland. Is anyone here on that case?
Yes, Your Honor, I am on behalf of the defendant, and we submitted an agreed scheduling order last Tuesday, the 19th. So
Take a look at
I'm not sure if we even need to still be here for this hearing or not, but that has been submitted and was agreed to by both parties.
Okay. Is this is this it right here?
That's it. Yes.
Okay. And is that a Tuesday?
I believe it's a Monday.
Yeah, we start our trials on Tuesday. Let me double check. Yeah, so we'll just move it to Tuesday.
Okay.
All righty. We'll go ahead and let's get this signed right now. And I will be back in a second. I'll go ahead and scan that and send it to court staff. All right, let's go ahead and go on to the next hearing. Y'all, I think the next hearing is going to be,
I'd be excused, Your Honor.
you may, sorry.
Thank you.
And I've signed and scanned the order and I sent it to court staff. So hopefully that'll get entered today.
Thank you very much. Have a good week.
No problem. Russell B. Pemberton, are both sides here for that?
I'm here, Your Honor. This is Andrew Larson on behalf of Patrick Russell, the plaintiff.
Okay. Is the defense counsel here?
I don't see him on the call yet, Your Honor.
Okay. Well, you get to choose when the trial's going to be. Have you guys, or unless you've submitted a scheduling order? You have not. So.
We did not, Your Honor. We did agree on a trial date of October 26th, 2021. That is a Tuesday. I just could not get a response from opposing counsel giving me the okay to file the agreed scheduling order.
Rhonda, go ahead and set this for trial on October 26th, 2021. A case of this age obviously probably won't get reached given our backlog, but you never know. So we're glad to set it then.
Okay. Thank you, Your Honor.
All right. Go ahead and set it then, Rhonda, and try to get us a scheduling order that when you can.
Okay. Thank you, Your Honor.
Thank you. All right, the next hearing is a default prove-up in the Bonini versus Perez case, or is everyone here ready for that one?
Yes, Your Honor.
And who's that? Who just spoke?
My name is Jordan James. I represent the plaintiff.
Okay. And is there a, do you have your client here?
Yes, she should be here. I just saw her in here. Moena.
I'm right here. My name is Moena Bonini. I'm his client.
Okay, great. Let me go ahead and do this. Did you already submit a default judgment here?
Yes, Your Honor.
You submitted an order?
If not, I can get one sent in afterwards.
Okay. All righty. Tony, are you ready?
Yes, Judge.
And are we currently on YouTube, Peyton?
Yes, we're still live.
Okay. All right. Let's go ahead and go on the record in this case. Let's go on the record, Tony, on cause number DC 208890, Bonini versus Perez. Counsel, make your appearances.
Jordan James, counsel for the plaintiff.
All right, and you're here on a default judgment. I assume as to damages. You may proceed.
A plaintiff calls as his first witness, Moena Bonini.
Ms. Bonini, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
You may proceed.
Can you please state your full legal name?
Moena Awo Bonini. I can take this off.
Please tell the court your age at the time of the accident that occurred on May 16th, 2020.
25.
What was your job title at the time of the accident?
A senior personal banker.
And would you please briefly describe the accident that occurred?
Yes, I got home from work on May 16th and I was reversing into a parking spot and I got hit on my driver's side.
Can you please tell the court your injuries?
Yes, my neck, my mid, and my lower back, and also my shoulders hurt.
Ms. Boweni, isn't it true you went to Momentum Spine and Joint on May 27th, 2020 and June 10th, 2020?
Yes, I did.
And isn't it true you went to MRI Centers of Texas on June 3rd, 2020?
Yes, I did.
And isn't it true you went to Uptown Radiology Associates on June 3rd, 2020?
Yes, I did.
And isn't it true you went to Memorial Care Pharmacy on May 27th, 2020?
Yes.
Will you please explain to the court how your neck and back has felt since your last trip to the hospital?
Since my last trip to the hospital, it felt better, but I've been experiencing some back pains recently.
Have you been told you will need any surgery or corrective action in the future?
No, but they did say that I can return if I do experience any more back pains.
How has the neck pain and the back pain affected your personal life at home?
It prevented me from lifting heavy things. It prevented me from working out. And it also prevented me from going to work at the correct times.
Has it limited your ability to do chores around the house?
Yes.
Is it still limiting you today?
No.
Did your injuries and limitations from your injuries affect you mentally at all?
Yes.
How did it affect you?
It made it hard to focus, and I was in like a depressive mood for like a few months when it happened.
Does it still affect you today?
No.
Did you miss any time from work?
Yes.
How much time did you miss?
I believe about 2 weeks.
Do you know how much you were making at the time?
It was around 40 per year.
Ms. Benini, are you asking the court to award you $9,622.45 in past medical bills?
Yes.
Are you asking the court to award you $40,000 for future medical expenses?
Yes.
Your Honor, I have no further questions for Ms. Benini.
Let me ask a question. Are you submitting any medicals as exhibits in this case?
Yes, Your Honor. My assistant, she should have filed them before the hearing, like this morning. They were supposed to get filed this Friday, but there was an emergency, a medical emergency on her end. But yes, we're getting them filed.
So these also under the Dallas County emergency order they need to be emailed to my court coordinator. What exhibit numbers are they?
There will be exhibits, should be 1 and 2 and 3, but whatever because we already have the other exhibits submitted by now. So
Whatever you're going to submit, because we have to admit them now. So how many different exhibits do you have?
There are 4 medical records. So there will be four
affidavits total?
Yes, sir.
All right. So you're offering 1 through 4?
Yes, sir. Yes, Your Honor.
All right. Exhibits 1 through 4 are admitted. But you have to, Tony, can you go ahead and put in the chat your email address so he can email you the exhibits? In the medical records, is there any proof of future medicals? You asked for 40,000 in future medicals. Is there any proof of that in the medicals?
Yes, Your Honor. She's been advised to return for treatment if she's still experiencing pain, and she currently still is experiencing pain, so she will be returning to the doctor for some additional medical treatment.
But is there an estimate of the cost of that in the records?
No, there is no future surgery estimates.
Or any type of future estimates?
Just the amount for treating as previously, and she'll be returning for more physical therapy.
Okay, so what are you asking for? Your for past medicals what's the total?
$9,622.45.
Past pain and suffering, what are you asking for?
$20,000.
Okay. Any impairment?
No, Your Honor.
Okay. And then she testified that she's not currently feeling any pain. And what is your basis for future medicals or future pain and
I-
suffering.
I believe she testified that her
I
pain
was
wasn't
feeling
affecting her
pain.
mentally anymore, but she still is experiencing some neck pain and discomfort.
Okay. Okay. Go ahead and submit the proposed judgment as well. Email my court coordinator, Rhonda, with the judgment. Email my court reporter, Tony, with the exhibits.
And both of those are in the chat, Your Honor.
Let me see. Rhonda, you can find online, so just get that offline. Let me see. Did you already enter in the chat?
I did, Judge. It should be showing.
I can see Tony's, Your Honor.
Okay. Yeah, you'll just need to get Rhonda's online. Okay, just go and get that to me, and we'll get that signed as soon as possible.
Thank you, Your Honor. May we be dismissed?
You may. Thank you so much. You guys be safe, Ms. Benini. I hope everything works out, and you hope you have a great day. Okay.
All right, thank you so much.
Appreciate it.
Thank you.
Bless you.
Okay. Do we have anybody here on any other cases?
Yes, Your Honor.
Okay. Is that on
I think we're
Roberson
all here on
versus?
the Roberson, correct?
Okay. Do we need a record for this hearing?
That's, I think I'd prefer one.
Okay. Tony, let's go on the record on cause number DC 1919685, Robertson versus Carter. Counsel, make your appearances.
Your Honor, this is Howard Mark Spector. I'm the move-in and I'm the receiver in the matter.
Okay.
Your Honor, Mark Mosley, I'm the attorney for the plaintiff, Ms. Martha Roberson.
Okay. Let's go ahead and proceed.
Thank you, Judge. About 2 weeks, you appointed, well, take that back. About a month and a half ago, you appointed me receiver under a conditional order entered on December 8th. As I understand that original order, it gave one of the parties time to fund a settlement payment to Mr. Mosley's client. When that payment failed to occur, my receivership kicked in. Mr. Mosley contacted me and informed me that I was the receiver for a property known as 10435 Chelmsford Drive in Dallas, Texas, 75217. I have visited the property on a drive-by. I am informed that it is vacant. I am also informed that it is uninsured. And those are two very, very bad facts, especially when they are both occurring at the same time. Because a property in this particular area of town it would not be uncommon for it to be occupied by a trespasser or destroyed by a vandal. So I conducted a very, very brief marketing process myself with investors who purchase these kinds of properties in as-is condition. In other words, not in a condition where it would require me to make any sort of repairs or improvements to the property. I received 5 offers in total, the highest of which at the time I filed the emergency motion was $65,250 from a company called Sneak Peek. I then filed my original motion suggesting that I be authorized to sell the property to Sneak Peek, and about 4 minutes after I filed that motion, I got a new offer for $75,000 from a new purchaser called PJA Management LLC. PJA's offer, however, would not close until March. Since the time I filed the amended motion disclosing both of these offers to the court, I have contacted PJA to see if they would match or even come close to the closing date that Sneak Peek had, because obviously I want to get as much money for the property as possible. PJA has not agreed to move its closing date at all. In other words, they would still require a closing in March. Their earnest money deposit is very, very small. And accordingly, the earnest money is $500. So they don't really have much at risk if they walk away from the contract before March. But obviously I have a duty to disclose both of those offers to the court, and it would be my recommendation to accept Sneak Peek's offer, even though it is lower due to the proximity and time of closing. I don't think it is advisable to leave a property vacant and uninsured for the better part of a month and a half I don't think the risk outweighs the reward. So I'd ask the court to approve the property sale to Sneak Peek under the offer that I originally filed the motion for, and allow me to close as early as this week.
Have you talked to the bidder who made the $75,000 offer to see if they could fund more quickly, or you said that they couldn't, I guess?
They just said they wouldn't. They didn't tell me why.
Okay. Mr. Mosley, did you want to say anything?
Just that I concur with Mr. Spector, Your Honor. Visited a property yesterday that had been vandalized. It had been vacant, and the resultant damage is likely to occur at our property. So Mr. Spector is absolutely correct. A close as soon as possible is imperative.
Mr. Spector, I see and let me share screen this so you can kind of see what I'm looking at. I see that you filed an emergency motion to authorize the sale, but I don't see an order. Did you submit an order with this or not?
I didn't, Judge, because I didn't know which one the court would approve. We can upload an order in the next 15 minutes.
Okay.
Or send it to your court coordinator, whatever you prefer.
If you could do both, go ahead and send it to Rhonda as well as upload it. And Rhonda, make sure you forward that to me as soon as we get it. And the $65,000 offer, given the situation, obviously I understand we don't want to have this property get any further damaged. The court will approve that.
Can I get Rhonda's email address?
Sure. It should be in the chat, but the chat.
I'll forward it to him, Your Honor.
Okay.
Thank you very much, Mr. Mosley.
Yes,
You should know whether the chat is, Mr. Spector, but that's okay.
I see the participant window, but I don't see a chat window.
Here, so on the bottom right, it'll say what I assume your screen is.
Okay, I got it. Got it. Thank you.
Okay. Wait, Ron, did you tell him to send it to your Gmail address? I think she may have. It should be rhonda.pinson@dallascounty.org. I think she accidentally put her personal email there.
I got it.
All right. Well, thank you for your service, Mr. Spector. I'm glad we're able to get that done. And you guys be safe, and you are excused.
Thank you very much, Judge.
Okay, Judge, on the Mark Home versus Five Star case,
Yes.
is that under seal for any reason?
I thought that maybe part of the case is under seal, like certain documents, but I haven't sealed the full case in quite a while.
Okay, well, I filed 3 volumes. And so in one of the, in Mr. Garris's letter to me, it said to file it under seal. But the Court of Appeal says unless they have an order from you sealing it, it won't be.
I think I had sealed some of the documents, and so that may be one of the documents I've sealed, but just ask her, hey, do you have a court order that requires this? If you do, go ahead and send it to me. I mean, obviously be nice about it, but it is, my recollection is that I did seal portions of it, but not the entire case, if I'm remembering correctly, because there was an issue involving compensate, like some of the executives' compensation and how much they were being paid, if I'm recalling this correctly, and anything involving that should be sealed. And so I don't know if this transcript that you're
And
doing.
we're still on YouTube also, sorry.
Oh, oops, sorry.